Okay, go ahead, Tom.
All right, thank you, Nicole. We're coming together today to meet in the subcommittee regarding the inquiry of Adams, dealing with the representation of privately retained counsel in a criminal matter. Members of the committee are hereby advised of the duty under the State Government Ethics Act to avoid conflicts of interest and appearances of conflict, and are instructed to refrain from participating in any manner coming before this committee with respect to which there is a conflict of interest or appearance of conflict. Is there anybody that wants to claim such conflict of interest at this point in time? Seeing none, I'll kind of turn it over to you at this point in time, Nicole, and you can bring us all up to speed. I see that John did join us. Good. Anyway, go ahead, Nicole. You're muted, Nicole.
Oh, thank goodness.
Sorry. It's not just you, Brad.
Thank goodness.
So yes, John Webster is with us, and then it looked like Mary is trying to join by phone. Okay, so this is the inquiry of Adams, and this is the proposed opinion regarding a client or criminal defendant who has been declared indigent and has appointed counsel, but then either the defendant or the defendant's family contacts a lawyer and asks that lawyer to provide limited representation to just handle a bond hearing on behalf of the defendant. So the ethics opinion goes through an analysis of one, whether or not it's a violation of Rule 4.2, which is the rule that says you can't communicate with a person or entity represented by counsel unless you have that lawyer's consent. The opinion provides that it is not a violation of Rule 4.2 because 4.2 allows a represented person to contact another lawyer for a second opinion or to discuss representation. So under 4.2, there is not a problem there. But then the opinion goes on to give an analysis of whether or not the privately retained lawyer can provide a limited representation under these circumstances, and references Rule 1.2 that says that a lawyer may provide limited representation only if it is reasonable under the circumstances. So in the past, we've talked about what is reasonable under the circumstances and whether or not the client gives their informed consent, meaning that they understand the limitation and consent to that. We also talked, or the opinion also discusses, excuse me, let me go back to my notes here, I'm sorry. Forgot my train of thought there. So that's on opinion number 2 about limiting representation. Right. And then opinion number 3 talks about if the family is going to pay this, or if the retained lawyer is going to accept a fee, does that have an impact on the defendant's ability to remain indigent, and what kind of effect it will have. The opinion also talks about that the retained counsel would need to communicate with appointed counsel to make sure that the client is completely represented and that there's no adverse impact. During the subcommittee meeting, you all discussed adding Rule 1.1 on competence. It was Takia Lewis, who is not present here today, but her opinion that providing limited representation is more about providing competent representation, meaning that you need to look at the discovery and know all the facts of the case, communicate with appointed counsel to make sure that the client is protected and covered. You also added in Rule 1.3 on diligence, which would include communicating with the DA, communicating with appointed counsel, and looking at the discovery. You also asked me to include a reference to those 2 rules, as well as 8.4D on conduct prejudicial to the administration of justice, and that was speaking more to the effect of the appointed counsel's presence and whether or not it would eliminate the defendant's status as indigent, which is a legal question that the ethics committee cannot opine on But nevertheless, the lawyer has a duty under the rules to make sure that the client will still be protected. When John Webster, you also, let me just back up, you also discussed the fact that different judges in different counties handle this matter differently, and whether or not they will allow appointed counsel to provide limited representation. And John was one of the lawyers that pointed out that this is a problem in his district. Burke said it wasn't a problem in his district. So where we are now is that I've added in all of the revisions that you guys asked me to make at the last subcommittee meeting, but we weren't able to meet again before the October meeting for you to review those revisions. So I sent you all of the revisions, and now we just need to discuss whether or not the opinion is fine as drafted. If you need to make additional revisions, if there's anything else that we need to cover.
All right, thank you, Nicole.
That's where we are.
I guess what I maybe just for the benefit of, so we kind of keep it flowing in the right direction, let's start off with each individual inquiry and opinion and see if there's anything that anyone wants to add or has concerns about, going forward. And that's with the first one. It's, may a lawyer communicate with defendant, knowing defendant is represented by an appointed counsel. And then Nicole, we have her opinion, or the proposed opinion. Anybody want to chime in? Anybody have any questions or concerns about that aspect of Nicole's presented opinion? Don't hear anything, don't see anything. Okay,
Yeah,
great.
good, no changes there.
What about inquiry number 2? May a lawyer limit his representation and undertake representation knowing defendant has appointed counsel? Obviously, opinion 2 is a little more lengthy, but I think that was kind of in response to some of the concerns a number of us had, in the last meeting. So I'll kind of open it up at this point in time and see if there's any concerns or inquiry that needs to be made about that aspect of the proposed opinion.
I think that can I just ask one question?
Go.
My understanding is that the way this came up, the context in which this came up was sort of, it's the beginning of a case. There's a bond hearing or somebody's in custody and they really want a bond hearing, and the public defender's office is unable in the immediate near term to do that because of other professional responsibilities and other things. And if that's the case, there is I guess what is added language about competence. It says the lawyer must therefore communicate with the defendant in the district attorney's office and review the discovery. And in my experience, discovery is not immediately available in that scenario. Like it's been a while since I had a Superior Court felony case, but it's everyone that I ever had never began with your client's been charged with a felony. Here's all the discovery. Oftentimes it can be in district court before it even gets to Superior Court. And then even in Superior Court, it doesn't come right away. So maybe that could just be gently modified to review any available discovery.
I like that. Everybody else seems to be nodding their head. I agree. I agree with you, Brad. We don't technically deliver discovery until after we've indicted a case. But we oftentimes will give informal discovery to an attorney that's made an appearance or has been appointed. And I think in this case, it was more of wasn't a public defender, but it was court appointed, privately retained or court appointed counsel. And then kind of lawyers from another area outside the district were coming in wanting to find out what's going on with the case and get information from the DA without really making an appearance and trying to influence the process of the bond hearing without really getting in the case. And that's kind of where everybody's antenna kind of got pushed up as far as how do we handle this situation, and that's what prompted the inquiry. So
Right.
I agree, and I agree with you. It should be available discovery. So
I mean, yeah, the point being, I think that, and I think it's really well covered in the language on this page, that you could do real damage walking into a courtroom and litigating some bond hearing without really being informed or informing yourself at least of available information about the case. And I do think that this language captures the need to not do that.
yeah, well said. Anybody else, anything else as far as inquiry and opinion, proposed opinion number 2? Yes, Bert's raised his hand. Go ahead,
Good
Bert.
afternoon. I sent this out to a couple of my my colleagues, and although most of us, or all of us, feel like the opinion is warranted and that there needs to be a left-right limit, and that appointed counsel as well as assistant public defenders need to be informed of of an attorney coming in for a limited representation, especially in bonds. They somewhat feel, especially one of them feels somewhat that this is all really going to be unrealistic, especially the cooperation between the local attorney or the private attorney and the court-appointed attorney. Discovery was an issue that they brought up, and I appreciate Brad bringing it up. But I think the quote was, "This is all lovely and good, but it's just not going to happen." And so I just wanted to throw that out as to how much is the bar going to, are we going to go to the mat when, especially, when you have language such as lawyer must also discuss with appointed counsel the evidence he intends to introduce at the bond hearing, including a list of witnesses and expected testimony. I'd be very surprised if that happens in our day-to-day practice. And so I'm being very candid with you. And so those are just the thoughts that I've received from the field. Thank you.
Okay. I guess I kind of see that playing out as you described, Bert, and I guess maybe could we tweak that language in some respects as just to make sure that whatever it looks like, that both counsels work together to ensure and protect the defendant's rights, and not so it doesn't necessarily mean that you have to work together, but you have to both be aware of what the other's doing to the degree that you're not going to jeopardize the defendant's position. I'm getting some nods of heads here.
Yeah, I
Okay.
think that's great. The critical thing of all this, from our standpoint, is that we just know about it.
Right.
And that was the hard thing, is that we didn't know about it until somebody calls us, or the clerk calls us, or a friend of ours calls us and says, "Hey, did you know so and so or so and so?" And it's just managing the expectations, and obviously managing the expectations of the client or the client's family. See, a lot of times I don't even know if the client even knows that they're working on behalf of them. I mean, it's the family hires. They haven't barely had any contact with the actual inmate. And so we don't even really know about it till we pull the shuck and take a look at it. So I don't know how that part's addressed, but I think some type of communication, firm communication, that they are getting into the case for this limited representation is extremely important, whether it's an email or a letter or some sort.
So Bert, in the second to last paragraph that starts with "before agreeing to represent defendant on a limited basis." So look at that in opinion number 2. And then the last few sentences, lawyer must also promptly inform the appointed counsel of his involvement, preferably before taking on the representation. And then the last sentence, failing to communicate the lawyer's involvement with appointed counsel under these circumstances would be prejudicial to the administration of justice. So does that satisfy, or is there someplace else in the opinion that you want me to add
Well,
language that the,
I mean, it satisfies. I mean, don't get me wrong. I mean, this is just a, you know, I'm just saying for more practical. I mean, the information, I mean, it pretty much says you must inform.
What if-
Definitely satisfies, just to what extent is that information, and to what extent does the court appointed counsel and the attorney really talk about it? Because a lot of times our folks, I say our folks, the attorneys are hesitant to even talk to the other attorney about it, about specifics, because we haven't even spoken to our client. I mean, this is all happening, and as most of you know, this is all happening within the first 96 hours of arrest. So, I mean, you know, things are extremely fluid during this time. And so sometimes the bond comes in before the paperwork is even assigned, and then I sign it to an attorney. So it's and as Tom and Brad knows, and I think the others know, and Mary as well, that the money that the private bar makes on these bonds are typically money is exchanged, business is done all within the first 48 hours of arrest, because that's where they make their money, because we haven't even gotten the shuck to assign the file to an attorney.
Let me ask the subcommittee this then, in light of that part of the second paragraph of, I'm sorry, what technically is the third paragraph that Nicole just mentioned, is that sufficient that we could possibly take out the last two sentences of the last paragraph of that opinion? Yeah, because I think that may be kind of what we're saying the rub is here, is that the lawyer and appointed counsel must work together and discuss the best strategies to ensure the defendant is protected and not harmed, where that in some sense of the word is covered by the paragraph before with respect to you don't want to be doing anything that's prejudicial to the administration of justice.
Or Tom, you know, I like, okay, I know I'm new to the bar, I mean, to the bar counselor thing, but I do like language that gives us guidance in the comment. And I don't have a problem with the language. It's the must part as opposed to the should. You know, there's a lot of shoulds that needs to happen, but it's the, if they don't do this, will this be used as a sword against them in some type of complaint? So
I will add, I agree with the
Go ahead, Robin.
I agree the language is good guidance. I mean, because I think it does help the defendant when the two are working together so that there's no miscue. But maybe putting should there instead of must could cover, you know, that what we're trying to accomplish.
Or maybe
so should work together as opposed to must.
Well, let me add something to this mix too. It seems to me that this places the superior burden here for making this situation work the best for the defendant is not the appointed counsel or the public defender's office. It's the person who takes money to get this done. And so I think that, you know, by definition, there's probably not an environment in which they can work collaboratively and their co-counsel and first and second, or the appointed lawyer would just be doing it. So I think it might be worth saying, you know, the lawyer, I guess, is the retained person in this fact pattern. Lawyers should endeavor to involve, should endeavor to involve, you know, inform appointed counsel and involve appointed counsel in any way that appointed counsel is ready and available to be, you know, involved. Because otherwise it almost seems like this is now placing a burden on appointed counsel. Like we have an ethics opinion that kind of in a roundabout sort of way now says, appointed counsel, you must stop what you're doing and work collaboratively with the person who's being paid to get this done on a near-term basis. So maybe that language could be massaged a little bit just to say something like that.
And in light of that, should the last sentence in that paragraph then be taken out? Because that's also a command. Lawyer must work with the appointed counsel as to the evidence to be introduced. And I mean, if you're doing it in such a way as to just not prejudice the defendant, then I think that's probably covered by the other parts of the opinion. And it takes out that command aspect of it, and does not put the court appointed attorney in a precarious position as opposed to the retained limited appearance attorney. Mary's got her hand up. Go ahead, Mary.
So I too am sort of new to this ethics subcommittee work. And is it possible to put those last two sentences into a comment to the opinion where you basically can qualify it with some of these concerns? Because it's basically if feasible, right? If feasible or if possible, the two lawyers should work together for the following reasons. And it also occurs to me that it says lawyer must also discuss with appointed counsel. If I'm appointed counsel, I would really like to know what happened at that bond hearing, right? If I'm coming in later. And I think the retained lawyer has a duty to sort of fill him in or her in on what happened. So it seems to me you could get into some of these nuances in the comment that you might not be able to in the opinion. So.
Good point. What do you say to that, Nicole?
So I can make it a footnote to find the right sentence that says that the appointed counsel must inform, that the retained lawyer must inform appointed counsel of his involvement. I can make it a footnote there and then change the language so that it reads, lawyers should endeavor to involve appointed counsel and discuss the best strategies to ensure defendant is protected and not harmed by lawyer's limited role. Lawyers should also discuss with appointed counsel the evidence he intends to introduce at the bond hearing, including a list of witnesses and the expected testimony of those witnesses.
Okay.
Does that sound better? So I removed the word must, included should, and then I'll put that in a footnote.
I do like the where feasible qualifier.
Yes.
That Mary suggested. A lawyer should, where feasible or when feasible, do all those things you just said, Nicole.
Yes, and I added that to the sentence before. Lawyer must therefore communicate with the defendant and the district attorney's office and review any available discovery. Okay, so here, competent representation also requires lawyers to communicate with appointed counsel. So I can make the last two sentences a footnote to that sentence. Just looking to see, where's the sentence that says he must inform them?
I think that's in the prior paragraph. Correct. It's
second sentence from the end.
Fifth line from the bottom, or sixth line from the bottom.
If I may, I guess when I had my previous comment, I really didn't take a look at the inquiry, but I mean, I did take a look at the inquiry, but it really didn't. I really didn't think about what it says when it says the lawyer limit his representation, undertake representation, knowing the defendant has court appointed counsel. Well, that knowing part, I mean, that could be a week or two, once someone gets arrested. I mean, they can assume and stuff, but especially if a lot of the bond hearing work, the majority of the bond hearing work that I see in my little foxhole is that first 96 hours. I guess most attorneys would say there's no way that they're going to be appointed a counsel and that a counsel gets signed. So I'm not going to have to really anybody.
But isn't it also true that they'll know that they've asked for a court appointed attorney, and even though they may not have an assigned attorney, if it's a public attorney in the sense that it's not a public defender, if it's like John, who's been, and the judge says, who's next on the list? John gets this case. John Webster's appointed. That will be in the file. If it's the public defender, then they know that the public offender has been appointed. And even though the public defender hasn't assigned the case to either someone in-house or farmed it out, they'll know where to go in order to have that communication, so to speak.
Well, Tom, I understand. All right. But if I may, you would humor me for a minute and let's play this out.
Oh, I've seen it played out in 96 hours or
I know,
less.
but
Yeah.
I know you've seen it played out a million times. I'm just saying, does the private attorney even contact the client in the first 96 hours? I mean, someone gets arrested, the family comes in and hires them. Do most attorneys just start working on that particular case, or do you think that the correct attorneys should be the ones who are doing it right, should be making every effort to try to get down there to the jail and actually have a communication with them before they start working on it?
Yeah.
I dare say I doubt there isn't much communication until, hey, guess what? I just got your bond reduced, you're out. That's the first time they've really communicated.
So if I understand what you're saying is that we need to make sure that whatever it is we decide has to have practical application from the reality of what we're dealing with. Okay. Mary, you've raised your hand again. Go ahead.
Yeah, I was just going to say IDS rules are that a court-appointed private attorney is supposed to meet with see their client, connect with their client within 72 hours. But the reality out there is that there's a lot of non-compliance with that, which is unfortunate. So for what that's worth.
Okay. Thank you, Mary. All right. So based upon Nicole's kind of modification of the footnote and the language, is it based upon our collective experience in this less than perfect world going to be practically applicable for a lawyer to, and from guidance perspective going forward for this opinion? I guess that's maybe ultimately the question we have to ask ourselves. Have we narrowed it too much, or have we made it, or if we keep it from an advisory perspective or a footnote perspective, when you're able to do those things, is that going to be sufficient flexibility, not only for the bar, but also for attorneys out there in the real world, out here in the real world? What say you guys? Go ahead, Robin.
I like the language that Nicole has suggested. Even if the lawyer discovers who the appointed counsel is afterwards, I still think they have a duty to say, I represented defendant. This is what I introduced, because it may be important to the presentation of the case. It's important to the defendant's representation to know what was presented. And so it says, I think we're saying whenever feasible, or at the earliest time possible. It does, while we're assuming that this may occur at different stages, because while most of them, like Bert said, most of them occur within the first 48 hours, but I've also seen cases where they occur a month in, where the families get restless and they want their loved one out. So, this is more attuned to that type of situation, really. And I'm not sure if Adams, if that was what she was envisioning, or he or she, I think it's a she. But nevertheless, even if the lawyer doesn't know who the appointed counsel is after the fact, I still think that they should touch base with the appointed counsel to say, I represented them at the bond hearing. This is who came forward, or this is what I had. I just think there's that handoff that should occur.
Okay. Anybody else? Excuse me. Okay.
I agree. I think there's language, and I first of all, I do believe we should keep the opinion as narrow as possible, because I don't want a world in which, and this goes to something I actually brought up in the full committee meeting. Mary was unable to attend, but the notes from the minutes from the prior meeting still need to be updated with some of the comments she made, because they're there's a comment attributed to Mary that is that I know is the exact opposite of what she said, which is, she kind of, the comment attributed to her favorably talks about taking money to come in and plead somebody guilty. And I know that's not, and I know that is the opposite. And I think what Mary and I have talked about this. So I'm going to stop talking for Mary now and ask her to,
Yeah, I was unable to attend that committee meeting, and Brad and I talked beforehand because the minutes I thought were inaccurate. My concern was about, because I had actually been contacted by a senior resident and his chief district court judge about that practice in their district. And I do not approve of that. I think it's an unreasonable restriction on representation, but that's outside the scope, I guess, of this narrower opinion. But I sure would like to see somebody address that, because it's bad and wrong. And I'd like to see the minutes updated, because that made me look kind of dumb.
So let me ask you, is it the minutes in the subcommittee report or in another?
It was the minutes from the last subcommittee meeting.
it's what you attached to the email you sent yesterday.
Okay, so I need to correct.
Yeah. But
All
I
right,
had my,
Mary. So can you just, I'm sorry, can you just tell me real quick what,
hold on, I have to open them up on another screen. I have the opinion opened up here. Hold on a second. I'm sorry, I'm having computer issues, which is why I'm talking with
Okay,
you on.
we
phone,
can do
even
this
though I'm in my
later.
office. Okay, thank you.
you want to, we can do it by email. I'll email you.
That'd be great.
Okay,
And I had my hand raised just because I wanted to say I agreed 100% with the statement that even if it's after the fact, the appointed counsel should have a duty to, I'm sorry, the retained counsel should have a duty to apprise appointed counsel of everything that has transpired.
Thank you, Mary. All right. Yeah, go ahead, Bert.
I agree as well.
Okay, thank you. All right. So with those modifications as Nicole has presented, is there any more discussion as to the inquiry number 2? All right, and then inquiry number 3, assuming that the lawyer has obtained defendant's consent to a limited representation, agrees to accept the legal fee from defendant's family in accordance with Rule 1.8F, may lawyer withdraw if the family is unable to pay lawyer's fee. I'll just open it up at this point in time. I'll be frank with you. It's been probably since before 1998 that I had to worry about getting paid to do my job. So I'm going to defer to those of you that this is more of a reality to you guys, and open the floor for that purpose as to the proposed opinion from Nicole.
Well, I guess I'll field that one first. I just think this question should be governed by any question about withdrawal because you're not getting paid, which is, did you make the proper agreement? Did you make the right agreement? Was the agreement reasonable? Is the client not complying with the agreement? And if you want to withdraw and you don't have the client's consent, you need to let the court know that, and you need to not withdraw if the court doesn't let you withdraw. Just kind of, and I think this paragraph is generally consistent with that. So I would just say it would be weird to me if somebody was coming in for like this kind of a precision, Bin Laden raid style representation where I'm just going to go in and come out, and that this would ever come up, but I think if it does, it should just be governed by the same rules that govern withdrawal or motions to withdraw at any other stage of the proceedings.
Okay, thank you, Brian. Anybody else? Okay, then I think that is an acceptable response by Nicole as to proposed opinion number 3. All right. Anything else that we need to talk about or discuss with respect to what we're trying to achieve within the confines of these inquiries and these opinions? All right. Nicole, what's our next step then? If that language, Bert's got his hand raised. Excuse me, I'm sorry.
I do have a comment that's not within the confines, but I would like to bring it up in the sense that is there a way forward that we should make a recommendation? And please, Brad and Mary and John, Robin, all of you, jump on me, but it is there, I am still stunned that there are courts out there that allow somebody to make a limited representation in Superior Court for a guilty plea. I don't even know how to answer that or fathom such a practice. And I understand about the private bar trying to make money. I recognize that, but should we recommend or should we punt it or push it to whomever makes these decisions to look at narrowing down when and where in criminal cases attorneys should be allowed to consistently and conforming across the state to make a limited representation? Because I understand bond hearings, I understand limited continuances, but other than that, and limited in district court, but maybe in juvenile court before it goes to Superior Court. But this bifurcating and splitting of hairs with limiting, I just don't get it, and I don't understand how judges could allow this to happen. And I wonder if the time, even if it becomes a general statute type thing for the General Assembly. And I just wanted to know what your thoughts are, if I'm just wasting my time and getting involved with attorneys and clients and scopes of representation. Thank you.
I don't think that's an unreasonable ask. And I think that honestly, that's why, thought it was important for Mary's comments to be changed, because, the next step in this is that it's, we can enter a limited notice of appearance to do bond motions. So why can't we enter a limited notice of appearance to plead someone guilty? And, I don't want to, Mary's smarter than I am. She's got her hand up. So.
I was going to say, I suggested to the judges that they didn't have to accept that, right? And that maybe they should make a bar inquiry, because I'm not, again, with the process, I've not seen it happen, but these were 2 very well-respected judges who reached out about it. And I'm sure that's not the only area where it's happening. And we talked about this some on one of the public defender calls, Bert, and you may have been on it, where we talked about kind of other things where you're kind of drawing the line, like people who will, I don't know, I'll handle your trafficking case in district court and that's it. Or I don't know, just kind of, there's a spectrum of what's reasonable, right? And I think we can agree that a bond hearing could be reasonable, and just to plead guilty is never reasonable, but there's a spectrum in there of troubling practices we see. So that's, I'll stop talking now because I will. Okay. I think Bert's raising his hand though.
Go ahead, Bert.
And Tom and Brad and Mary, I know you've seen the statistics, but we have had a sea change over the last couple of years with Superior Court judges. So we have a lot of new judges on the bench, and therefore I'm somewhat, I guess, concerned about different districts doing different things. And I understand that's the nature of our business. I recognize that. I just wonder if out of this subcommittee, if we could maybe push up to the ethics, saying that that we suggest or we recommend looking at limited representation for criminal cases, about specifically when an attorney can do that, and then just push it to whomever bailiwick that is. That's all. Thanks.
Nicole is.
So, I think the only thing that the ethics committee could do would be to issue another opinion, a separate ethics opinion on that. I don't think that we have any authority to go to the judges and tell the judges what they can or cannot do. So I think the only way that we could do that is if we had another inquiry
Well,
for a
would we,
certain ethics opinion.
I'm sorry, would we be able to make this one that one? Like since we all have this concern, particularly those of us, who are in practice, it just seems like since this is probably the next thing coming, and I guess I would also add, since it's probably causing harm, currently, and until any practice about it is clarified, it might be that we need to wade into the broader issue of when are limitations reasonable, not just in this scenario, but more broadly, and then use an example, a bond where it could potentially be, and use an example as coming in under the condition you plead guilty might not be. And I'll say one thing about, like, I do know a number of lawyers, and I have been one of them, who has done a structured fee agreement where if a case was resolved before a trial, it was a certain fee. If we had to go to trial, it was another fee, understandably, because it costs more money and time to go to trial. But it was never, if you don't plead guilty, you're going to have to pay me more money. It was just an arrangement about tiered representation, because that often helps the client. It often hurts me, actually, to do that, but it often helps the client to do that. So I think we'd have to also distinguish those things, and it might be that that's worth doing. I don't know. I just put it up there.
John, you got your hand up. I'm sorry, Nicole, did I cut you off?
No, go ahead, John.
Okay.
I was just going to say, honestly, to that point, I think that next level of inquiry is probably the most problematic. This bond hearing thing really isn't, I mean, it's a problem, but it's not the bigger problem. The bigger problem that I see is exactly what Brad and Bert are talking about. These people that come in and will limit representation along the way to district court representation on serious felony. That means absolutely nothing. Like, how do you limit your representation on a serious felony to district court representation and grab a $5,000 or $10,000 fee? And when it gets indicted, you're like, oh, well, sorry, can't help you anymore. And we're from the appointed perspective, the appointed lawyers are stuck, just dangling on the hook. And that's what my comment was the last meeting. And I know it doesn't have anything to do with this inquiry, but I think it would if we went further into this, that the court-appointed lawyers are just stuck. The judges have taken the position that they're not going to let the appointed lawyer out until the other lawyer makes a full appearance and is all the way in with both feet. And that often takes us right up to the doorstep of a trial, where we're standing there having not talked to the family and not talked to the defendant because they've chosen to talk to this knight in shining armor that's taken all their money. And we get stuck and the trial calendar comes out and the judge says, well, trial's in 2 weeks. Sorry, you're going to have to represent him or her, whoever it is. That's the next level of inquiry I think Brad's talking about. And that to me is the most problematic thing, not so much what we're dealing with. I agree with all this, as far as the opinion regarding the bond hearings, but the limitation doesn't stop there. It goes far beyond that, almost to the doorstep of trial in certain cases.
Thank you, John. Nicole just posted a note in our chat, and that's kind of where I was going to go. Why don't we do this at this point in time, if it's okay with everybody? We kind of accept the opinion that we have, whether we're going to present it for then publication, I think is the next step, if it's as is, or if after maybe Nicole discusses with Brian kind of what we are talking about, whether that's a natural progression of what we've kind of started here to either be included within this opinion, or to somehow, it then morphs or changes into a whole different inquiry, how that should be, what they should look like within the confines of the state bar makeup. Bert's also made a note that if you don't have your chat on, Bert said maybe a task force with the judges and the state bar to look at the issue, as any resolution may require a statutory resolution. Again, I think that is the reality of kind of what we're talking about and where it would go to, and the breadth of it, of what kind of changes would have to take place. Clearly, I don't think there's something that we can touch within this opinion, but I think we all agree that that is going to be the natural progression of this inquiry. So I know we got about just a few minutes left of this time. So Nicole,
let me just make one comment on that.
Go right ahead.
What we could do is add a note or an editor's note to this opinion, that this opinion is limited to limited representation for a bond hearing. And so that way, at least we know that this does not apply to felony pleas or anything like that. And then discuss, I'll discuss with Brian, and then we can discuss with the full committee whether we should have a separate inquiry that addresses limited representation for felony cases.
Is that okay
that's
with
an
everybody?
option if you'd like to do it that way. And you don't have to decide right now. We don't have to rush this. We can take this to the full committee and ask the full committee to give their opinion on it, or you can just unilaterally decide now, we want to limit this opinion to just bond hearings. And then we'll address other limited representations in felony matters in a separate opinion.
If we can do that, then I think that kind of covers what Brad was saying earlier about the natural progression, as well as Mary before she signed off, of this issue. And if that's the case, then if that's acceptable to the membership, then let's do that. And Nicole, when you kind of finalize the kind of tweaks that we've talked about today, send it out to the membership. And if agreeable, and if something, obviously, Nicole, if something changes in your discussions with Brian, then, we may have to not technically submit this to the full committee for publication and kind of hold back, depending on how that is to evolve, so to speak.
Okay.
Brad, you got your hand raised. Go ahead.
Yeah, the only counterpoint I would say to that is I wouldn't necessarily want a world in which there are multiple FEOs out there about multiple stages at which you could limit your representation and, require lawyers to make sure, I know all of these rules, and I'm sorry, all of these ethics opinion and cross-reference. And if it is the will of the full committee or whoever else, or if Brian thinks it's advisable, this might be one of those scenarios where it would make more sense to broaden this to when is it acceptable to limit your representation in a criminal case under the rules of professional conduct, which include conflict rules, which might come up if you're charging somebody to plead them guilty. And so I think that just part of the discussion should be, if we definitely think this issue is on its way to some kind of a determination, we might want to consider using this opinion to sort of give representative examples of, this is when you can certainly do it, this is when you certainly can't, here's the rationale for those things for any other limitation you might be contemplating in your future.
Okay, well said, Brad. Maybe we should just kind of hold that answer to that question until we hear from Brian and Nicole, if that's okay with everybody. Yeah, okay, let's do that then. Thank you, Brad. Thank you, everybody. Is there anything else to be brought forward to the subcommittee at this point in time? If not, I want to thank everybody for your participation. Nicole, you did a great job in your inquiries and your opinions. Well done. Thank you, guys, and we'll be in touch in the future going forward in this matter. Thanks again. Have a good day.
Thank
See
you,
everybody.
everyone.
Bye. Thank you.
So.